This is the Parliament Channel and Parliament Radio 105.5 FM.
The Honourable, the Speaker.
You have the numbers, right? Remember, for Princestown, you have 15 minutes left.
Thank you, Madam. Madam, picking up from where I left off, I was discussing a contribution that was made by Minister, the Honourable Audley Shaw, Minister of Finance and the Public Service in the Jamaican Parliament, with respect to the amendment bill on the Property Tax Act. Madam Speaker, I wanted to quote from that speech that the Honourable Minister would have given. And it says this, and I quote, Mr. Shaw stressed that 61% of all property owners will see a very small increase of no more than 12% with their taxes last year. Also, the Finance Minister said that despite the reduction in the rates, it is expected that some property owners will also see increases, large increases. But the Honourable Minister went on to say, Madam, which is the important part, and I quote, the Minister says, let me also state that the government has no intention of taking away anyone's property because they are facing financial or other hardship. For those who have already paid their property taxes on the previously announced rates, any overpayment will be refunded or can be credited towards tax liabilities in financial year 2018-2019. He added that notwithstanding the lower rates that have been announced, we are still committed to providing assistance to those who are unable to pay and to facilitate those who wish to make objections. And Madam, it is in that context that I referred to India, where in rural areas they have zones that they have established for these exemptions. Similarly, in South Africa, there are categories in terms of levels of income where you do not pay property tax based on your income. And Madam Speaker, the cultural realization of a lot of these Commonwealth countries that we share similar jurisprudence with tells the story of very similar to a reaction that Jamaica had to have with their particular amendment in the 2017 amendment bill on March 13th. Madam Speaker, another very important issue that I would like to spend some time on would be the issue that is identified in the Land Valuation Act Amendment of 2018, clauses 13 and 14, which establishes the tribunal, but also in doing so, Madam Speaker, what it does, it replaces or rescinds the tax appeal board in terms of the jurisdictions that they would have had in order to deal with issues arising with respect to objections and so on, Madam Speaker. Madam Speaker, I know publicly the member for Siparia has expressed the opposition's concern with this particular point. And Madam Speaker, I want to take a specific look, again, with several of our Commonwealth jurisdictions. When you look at the Barbados model with respect to their tribunal in Barbados, Madam, when you look at the Canadian model, you look at the South African model, the Irish model, Madam Speaker, what it does is that it clearly observes the separation of powers. And Madam Speaker, what this seeks to do with these provisions is to continue to undermine, and this has been a pattern, Madam Speaker, a pattern that we are seeing that has developed over the years by successive PNM administrations with respect to threatening the separation of powers in this country. Madam, when you look at the repeal or the attempt to repeal the Tax Appeal Board Act, we have to look at the provisions in terms of the establishment of the Tax Appeal Board. Madam, what you will see when you look at the Tax Appeal Board, the Tax Appeal Act, Madam, which has not, and by admission, the Minister has indicated by some over 48 years that the Tax Appeal Board, the Act has not been reviewed. Madam, what you will see is that the Minister has removed the power of the President. Madam, what you will see is that the Tax Appeal Court, which is likened to a superior court, the chairman of the Tax Appeal Board, Madam, is appointed by the JLSC, the Judicial Legal Services Commission. That provides a safeguard in the legislation to ensure that there is no political interference by those who wish to create mischief. And again, Madam, we have seen time and time again where the hand of politicians have depleted the independent institutions in our country with respect to the way in which they administer and carry out their functions. Madam, the proposal as it stands in the legislation puts the minister, meaning the Minister of Finance, to appoint the chairman of this tribunal and 2 other members. Madam, it is very vague and it is totally unacceptable. And I'm sounded warning now, Madam, on behalf of the member for Sipari and all of those who sit on these opposition benches as responsible members of the opposition, that we will fight tooth and nail to remove the hand of the political directorate through the minister and ensure that the powers afforded to the president under this act remains. But more importantly, Madam, when you look at the Bayesian model as compared to what is being afforded to us under this amendment, this is what the Bayesian model has to say, Madam. And as I've indicated, several other jurisdictions in the Commonwealth that we share the jurisprudence with shares this model. And again, had the Minister of Finance and the Attorney General taken a look at the way in which the tribunals were set up to ensure that we maintain the separation of powers in this country, they would have seen in the Barbados Administrative Appeal Tribunal, when it comes to the property tax, that Section 4.2, it says, and I quote, "The President shall be appointed," meaning the President of the Administrative Appeal Tribunal, "by the Governor General, acting on the recommendation of the Judicial and Legal Service Commission by instrument under the public seal, and shall be subject to removal and disciplinary control in accordance with Section 93 of the Constitution." Madam, Section 4.3 goes on to say, "The legal and ordinary members shall be appointed by the Governor General by instrument under the public seal and shall hold office upon such conditions and for such period of time as it may be specified in the relevant instrument of appointment." Madam, the Act further goes on to indicate what will be the remuneration and the skill sets that have been identified for members to actually sit on the Administrative Appeal Tribunal. Madam, as it stands now, it gives a blanket proposal in terms of the qualifications and the areas of expertise that the minister can determine in terms of who will sit on this appeal. Madam, that is totally unacceptable. We will not participate in that travesty in terms of eroding the separation of powers in this country. We will not. You know, Madam, we have repeatedly said, we do not trust this government. We do not trust them because of their track record and their history has always had this sort of political interference in independent institutions in this country. And therefore, we advocate a similar approach be taken with respect to the appeal tribunal. Madam, in the few minutes I have left, I want to turn to a case with respect to an Irish parliamentarian who in 2014 when the Irish parliamentarian was faced with whether or not he will support, through his vote, the amendments to the property tax at the European Union Parliament level, Madam. Madam, the member, Paul Murphy, refused to give his support. You know why, Madam? He refused to give his support to this property tax amendment to impose stiffer and harsher conditionalities on the people of Ireland, because Ireland was identified as one of those countries as a tax haven. Madam Speaker, I ask, where is Trinidad and Tobago with respect to having been removed from this blacklist by the European Union? And Madam Speaker, I see the Honourable Attorney General is scoffing, but that is the reality, that while you are taking from one hand from the people of Trinidad and Tobago, Madam, your duty is to ensure that their public interest is kept. What have you done with respect to that, Madam? Absolutely nothing. You know, Madam Speaker, as I said in the few minutes that I have, there are several issues that we have identified with respect to not only criticizing the clauses and the legislation, but also providing sustainable solutions. And even if you cannot take all on board, do the honorable thing. Do the honorable thing by giving more purchasing power to the consumer, which is a citizen of Trinidad and Tobago. Not only taking from them, but being able to give back. Madam, I know we spoke about the issue of the local government reform, but that is an expectation that this population has. The expectation is that if the government is taking from one hand, then we must be getting something in return. And that is the point the member for Tabakit was making. Where are the improvements in garbage collection? Where are the improvements in play parks? Where are the improvements in schools? Madam, there are 4 schools in my constituency still remain closed, Madam. Madam, the Parvati Girls and Shiva Boys College remain closed. Madam, the UWI South Campus remain closed. And we were promised that if we gave this power with respect to property tax collection, we would have seen improvement in the lives of the people of Trinidad and Tobago. You know, Madam Speaker, yes, but we are not hearing anything about the reforms. So on one side, you're saying, give me, give me, give me. But you're not saying how it is going to benefit the citizen. We have seen millions of dollars in paintings. We have seen millions of dollars in mega projects, where we are not seeing it to the benefit of the people of Trinidad and Tobago.
Okay. So you could continue. Not on that point. You know why I stood up.
Thank you, Madam. Madam, in the few minutes that I have remaining, as I said, I have dealt with the clauses that we have particular concerns with, but also we have been able to provide solutions, and I am hoping that we look at the context of other developing countries whose legislation as well is evolving. Their legislation in many other jurisdictions is evolving, but it's how really we take them on board. It cannot be that we just come and speak for speaking's sake in this parliament, and therefore we do not give the opportunity for innovation and for growth and for development. Madam, if you would allow me, I know in the next few days that the Hindu community will be celebrating the occasion of Phagwa. I wish to pay my respects to the Hindu community on this very significant occasion. But Madam, later on in this week, we will also celebrate and join with the international community in celebrating International Women's Day. Madam Speaker, we have reached a very pivotal and significant point in the history of Trinidad and Tobago. We have assisted in further cracking the glass ceiling with your ascension, Madam, as a female in the position of Speaker of the House, but we have also seen it with respect to the member for Arukambaloni as a leader of government business, also our first female president. But Madam Speaker, a woman who has given so much to Trinidad and Tobago and who has developed the entire country, the length and breadth of this country, and really have put the power in the hands of the people in terms of the development, the first female Prime Minister, the Honorable Kamala Persad-Bissessar. Madam Speaker, it is in that context that we continue to be a voice, whether it's on property tax, on the Land Valuation Act, but we continue to be a significant voice for the people of Trinidad and Tobago, and we applaud all the women who have really given their heart, sweat, and tears to the development of Trinidad and Tobago.
Do I call on the Minister of Finance?
Thank you, Madam Speaker. Madam Speaker, I don't know what's going on there. We gave them ample opportunity to speak and they didn't want to speak. So we shall finish this debate. And Madam Speaker, let me deal with two issues. Madam Speaker, I'm being distracted. Madam Speaker.
As Speaker, I know nothing about agreements. I am not, Member for Point of Pear, you know much better than that. I stood up, I waited, I looked left, I looked right. In fact, before calling on the Minister of Finance, it was almost an inquiry. Nobody stood up. Minister of Finance.
Thank you, Madam Speaker. I don't know why honorable members over there didn't want to speak. Madam Speaker, I'm being distracted.
Honorable members, I am on my legs. I am on my legs. I would like to remind the whip and the leader, they have certain responsibilities. It is not the responsibility of the Speaker. Minister of Finance.
Thank you, Madam Speaker. Madam Speaker, let me deal with some of the issues raised by honorable members opposite in reverse order, because it is obvious to me, Madam Speaker, that members opposite did not take enough time to research the bills before us and to inform themselves on the true content, effect, and import of the legislation.
Minister of Finance. Minister of Finance.
Thank you, Madam Speaker. Madam Speaker, the last point made by the honourable member for Princestown with respect to the separation of powers and the judicial independence of tribunals and so on, the member was at pains to make a big song and dance about this issue. But it is clear to me that the member did not read the bill. And I will now put into the record what appears on page 9 in 25G, where under clause 15, we are inserting a new part. And I will read into the record. The Valuation Tribunal, this is the tribunal that would deal with appeals respect to valuation of land and property, shall hear all appeals raised under this Act or any other written law in respect of decisions of the Commissioner, and that will be the Commissioner of Valuations, take all steps that it considers reasonable and equitable in the circumstances to effect an amicable settlement of an objection, and may adjourn a proceeding at any stage to enable the parties to negotiate for that purpose. And more importantly, Madam Speaker, we are inserting a new clause 25G2, and this is what is critical and important. The Minister shall not give directions to the Valuation Tribunal in respect of any particular application or proceeding before the Valuation Tribunal, or a direction that would derogate from the duty of the Valuation Tribunal to act judicially. So, Madam Speaker, it is clear, it is going to be put into the law that the Minister of Finance cannot give instructions or directions of any kind to the Valuation Tribunal. And, Madam Speaker, it is important to read the next section. The Valuation Tribunal may, on its own initiative or on the application of a party, refer a question of law arising in a proceeding before it for determination by the High Court. Where a question of law arising out of a proceeding is referred to the High Court, the Valuation Tribunal shall not make a decision until the question is determined by the High Court or proceed in a manner inconsistent with the determination of the question of the High Court. So what this means, Madam Speaker, if a property owner objects to a valuation that is placed on a property by the Commissioner of Valuations, the property owner may do two things. They may appeal to the Valuation Tribunal, who would try their best to settle the matter amicably, or if they are not satisfied with the way the Valuation Tribunal is dealing with the matter, they can go straight to the High Court, Madam Speaker. Compare this to what happens now. A person who is aggrieved about the tax on property must go to the Tax Appeal Board, which is a superior court of record, with all of the attendant issues associated with that. The Tax Appeal Board already is seized with the responsibility to handle appeals of assessments of income tax, corporation tax, petroleum profits tax, value-added tax, and so on, Madam Speaker. And for those who know, matters are taking quite some time to pass their way through the Tax Appeal Board, years sometimes. And it would be unconscionable to now add to all of the matters that are with the Tax Appeal Board, all of the appeals that may arise from this Valuation of Land Act, Madam Speaker. This is the reason why it is the government's intention to create this tribunal, and if a person is aggrieved, they go straight to the High Court. In the current case, you have to go to the Tax Appeal Board, go through that process, which could take years. You have to hire lawyers, you have to make submissions, you have to produce arguments and so on, Madam Speaker. And if you're aggrieved, you then go to the Court of Appeal. This is a much simpler, a much less costly, and a much easier system. And with respect to the question of the minister appointing, it is trite law, Madam Speaker, that in the Interpretation Act, the power to appoint includes the power to remove. Exactly. That is trite law in our Interpretation Act. Absolutely. In an Interpretation Act of Trinidad and Tobago. That is trite law. It is well known. It has been tested on umpteen occasions, Madam Speaker. And it is stated in the Interpretation Act that the power to appoint also is the power to remove. So if the minister appoints, then consistent with the Interpretation Act, the minister can remove. And the minister can only remove for acts of mental incapacity, physical incapacity, misbehavior, and so on. And as my learned colleague from Laventil had indicated, that would be subject to judicial review. So if the minister acts whimsically or capriciously, then an aggrieved member of the tribunal can file for judicial review on the grounds of unreasonableness. But more importantly, Madam Speaker, there is extensive case law on whether a tribunal that is appointed by a cabinet or by a minister, whether that tribunal meets the test of our Constitution, Madam Speaker. And for the members opposite who clearly really need to get a refresher course in law, they really need to get a refresher course in law, Madam Speaker, I would refer honorable members opposite to the Court of Appeal decision, Civil Appeal number P129 of 2012, between Paul Lai and the Attorney General of Trinidad and Tobago. And in this particular matter, the Court of Appeal was looking at an appointment to the Industrial Court. And Madam Speaker, as you know, and members opposite should know, one expects that they would know, because there are some members of the former cabinet over there. The members of the Industrial Court are selected by the cabinet, as you would know, and what members over there should know, because they would have participated in cabinet proceedings where they would have appointed several judges to the industrial court. And in this particular decision, Madam Speaker, the question is that whether a reasonable and informed person viewing the relevant statutory provisions in their full historical context would conclude that the court or tribunal is independent. This is our Court of Appeal. They drew upon a judicial precedent from all over the Commonwealth and concluded that you have to look at the legislation and determine whether the tribunal would be independent. You do not have to clothe it with the full judicial powers of a court of superior record, Madam Speaker. So this is our law. This is our court. This is the precedent in our law at this point in time, that you don't have to automatically have high court situations with respect to any tribunal. You have to look at the context in which the tribunal is established and determine whether it is independent. And I put it to this Parliament, Madam Speaker, that these words make this tribunal totally independent. The minister shall not give directions to the Valuation Tribunal in respect of any particular application or proceeding before the Valuation Tribunal, or a direction that would derogate from the duty of the Valuation Tribunal to act judicially. I put it to this Parliament, Madam Speaker, that is the supreme test of independence. The minister cannot direct the tribunal, and they will make their own decision in their own deliberate judgment, Madam Speaker. That is a completely independent tribunal, fits well within the case of Paul Lai versus the Attorney General of Trinidad and Tobago. And coming now to the other examples about what is done in Jamaica and what is done in India and so on, Madam Speaker, what the honourable members opposite failed to disclose is that at the present time, the taxation on property in Chaguanas, for example, in the borough of Chaguanas, they failed to disclose this, is 10% on residential properties, 10% on commercial properties, 10% on industrial properties, and most importantly, 10% on agricultural properties. When they were in government, they didn't change that, they leave that just so that in the borough of Chaguanas, it's 10% across the board. Compare that to what we are doing. We are imposing a tax on agricultural property of 1%. 1%, 1/10 of the tax that they were satisfied with, Madam Speaker. So you cannot in any way compare our property tax law and its application to anything of the example, any of the examples by the honourable members opposite. Our property tax will be almost the lowest in the world. There are members in this Parliament, there's one who's been absent for a long time, the member for St. Augustine, who has a property in Florida.
One.
What? The member for St. Augustine is the owner of a property in Florida. And I say this without any fear of contradiction. It's online. And the tax on that property is $30,000. $30,000. And he pays it happily. Happily. Our property tax will be almost the lowest in the world. So when the honourable members are giving examples, they give us numbers. Give us a tax in another country where somebody's will only be required to pay $81 a month. Give us that. You can't. Because this is a fair, just, and equitable tax, Madam Speaker. It is proportionate, it is reasonable, and now to deal with the argument about what the tax would be used for. That is a ridiculous proposition, Madam Speaker. Ridiculous at the present time. At the present time, Madam Speaker, the local government bodies receive in excess of $2 billion a year. $2 billion a year. The property tax would not reach anywhere close to $2 billion a year, Madam Speaker. And therefore, if the corporations were to collect all of the tax, whether industrial, agricultural, residential, commercial, on plant and machinery, it would be less than the money they already receive. Less than the money they already receive. So it is a nonsense to ask what this tax would be used for. Clearly, this tax would be to give the corporations cash flow and to give them an income stream that they do not now currently enjoy, Madam Speaker. Clearly, if you have in the allocations and the appropriations to corporations such as Port of Spain, San Fernando, Chaguanas, Cuba, Tabaquite, El Paro, and so on, and you have line items, recurrent expenditure, capital program, roads, bridges, desilting of water courses. It's all there in the estimates of expenditure. And clearly, yes, all public health and so on, rodent control, it's all there in the books that we lay in this Parliament every year, Madam Speaker. And clearly, any cash collected by the corporations would be used for the line items in the budget in the appropriation bill, Madam Speaker. What other purpose could it be used for? It is a nonsense to ask what the property tax would be used for. Of course, it will be used to provide goods and services in the municipalities, in the corporations, to improve local roads, to desilt water courses, to collect garbage. Obviously, that is what it will be used for, Madam Speaker. It's a nonsense to ask what it will be used for and to complain that the money will only go into the consolidated fund. And even if it did, the money from the consolidated fund is used to pay salaries, wages, to purchase hospital for the medicine for the patients in the hospital, to provide old age pension, to provide social relief, and so on, Madam Speaker, and to be appropriated out of the consolidated fund into the line items and the votes for the municipal corporation. So it is just a nonsensical argument, Madam Speaker. It makes absolutely no sense. What we are about today, we're simply cleaning up the Valuation of Land Act and the Property Tax Act, Madam Speaker. We are introducing a very innovative appeals process, far from what members are saying. Far from what members are saying, we are introducing a very innovative appeals process to allow mediation, to allow amicable resolution, to protect taxpayers from having to hire lawyers and to engage in expensive and acrimonious litigation. We're introducing alternative dispute resolution, and contained within the legislation, which they fail to see, is the fact that the person will always have the option, if they are not satisfied with the process of appeals and adjudication by the tribunal, to go to the High Court. They can go to the High Court in the middle of the process if they are not comfortable. They can go to the High Court at the end of the process. We are not taking away any of the constitutionally protected due process rights of our citizens. We're making it better. We are avoiding expensive litigation, Madam Speaker. And therefore, Madam Speaker, I cannot accept any of the arguments made by members opposite. None of them. Imagine 1% on agricultural land, and that is 1% on the rental. You're talking about cents on the dollar, Madam Speaker. The property tax on an agricultural plot will be a couple of cents, Madam Speaker, because it is 1% of the rent. And what is the rent on agricultural property, Madam Speaker? It might be $100 for the year. On some agricultural properties, $100 for the year. You divide that by 12, you get $8. And then you apply 1% to that, you get 8 cents a month is the kind of charge that someone will be required to pay in terms of tax on agricultural properties. You're going to tell me a farmer can pay 8 cents a month, Madam Speaker? 8 cents a month, or 10 cents a month, or $1 a month? And you see, Madam Speaker, when they make their arguments, they don't bring facts. So they say in India, there are areas where you don't pay tax on agriculture properties. And in Trinidad, it's punitive and horrible of us to do that. But they didn't say that the farmer will be paying $1 a month. $1, Madam Speaker. And that, for them, is putting the population into poverty $1 a month. Pauperizing a farmer, $1 a month, and pauperizing a property owner, $80 a month, Madam Speaker. I am sorry, I cannot accept that. I just cannot. And with those few words, Madam Speaker, I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Valuation of Land Act, Chapter 5803, be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Valuation of Land Act, Chapter 5803.
Minister of Finance.
Madam Speaker, in accordance with Standing Order 681, I beg to move that the Valuation of Land Amendment Bill 2018 be committed to a committee of the whole. One to the podium.
Honourable members, the question is that the Valuation of Land Amendment Bill 2018 be committed to the committee of the whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the committee of the whole to consider the bill clause by clause.
Clause 1.
The question is that clause 1 stand part of the bill. For the information of members, we are looking at the Valuation of Land Amendment Bill. The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. The question is that clause 2 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 2 now stands part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. The question is that clause 3 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 3 now stands part of the bill.
Clause 4.
The question is that clause 4 stand part of the bill. The question is that clause 4 now stands part of the bill. Those in favour say aye. Aye. Those against say no. No. I think the ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that clause 5 stand part of the bill.
Madam Chairman, I would like to make a minor amendment. There's a little typographical error in clause 5. In 5B, 5 instead of the minister may by order amend the schedule, it should be the minister may by order amend schedule 2. So we'd like to delete the word the appearing before schedule and add the number 2 appearing after schedule. Roman numeral 2, actually.
Yes, sir.
This is on, so it will read the minister may by order amend schedule 2 instead of amend the schedule.
The question is that clause 5 be amended as follows. In clause 5B, subclause 5, the minister may by order amend schedule 2. Yes, Roman numeral 2.
That's it.
Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The question is that clause 5 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it.
Clause 6.
The question is that clause 6 stand part of the bill. The question is that clause 6 now stand part of
Madam.
the bill.
Madam, with reference to clause 6 and the insertion of new clause 7A, where it says it will require the commissioner where he is of the view that the more than 50% of all lands in Trinidad and Tobago is invalid to notify the minister who would by order then declare that the valuations are in effect. I'm raising this in the context of, again, appealing that when you go on to clause 7, you would say that the president in this circumstance is being removed to insert the minister, and clause 7A would give effect again to this.
Madam Speaker, I don't know if the member knows that constitutionally the president means cabinet in this case. This is not the president of His Excellency, the president acting in his sole discretion. This is not His Excellency, the president acting in his sole discretion, okay? President means cabinet.
Madam Speaker, for the benefit of the honourable member, I refer you to section 8A1 of the Constitution, where the parameters of the president acting in various capacities is clearly set out. It's read in conjunction with section 74 of the Constitution. In this instance here, there's no qualification language that the president exercises in consultation or of his own volition, and therefore it is on the advice of cabinet. So the minister is the same as the cabinet.
Okay, understood. Thank you, AG.
Okay. The question is that clause 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 6 now stand part of the bill.
Clause 7.
The question is that clause 7 stand part of the bill. The question is that clause 7 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 7 now stand part of the bill.
Clause 8.
The question is that clause 8 stand part of the bill. The question is that clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 8 now stands part of the bill.
Clause 9.
The question is clause 9 stand part of the bill. The question is that clause 9 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 9 now stands part of the bill.
Clause 10.
The question is that clause 10 stand part of the bill. The question is that clause 10 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 10 now stands part of the bill.
Clause 11.
The question is that clause 11 stand part of the bill. The question is that clause 11 now stand part of the bill. Those in favor say aye. Aye. Those against say no. Ayes have it. Clause 11 now stand part of the bill.
Clause 12.
The question is that clause 12 now stand, no, the question is that clause 12 stand part of the bill. The question is that clause 12 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 12 now stand part of the bill.
Clause 13.
The question is that clause 13 stand part of the bill. The question is that clause 13 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 13 now stand part of the bill. Is it the wish of the committee that all the remaining clauses from clause 14 to 19 be done together? Okay. So the question is,
Clauses 14 to 19.
the question is that clauses 14 to 19 stand part of the bill. The question is that clauses 14 to 19 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 14 to 19 now stand part of the bill. Honorable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The schedule is closed 19. Minister of Finance.
Yes, ma'am. Madam Speaker, I wish to report that the Valuation of Land Amendment Bill 2018 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that this House agree with the committee's report on the Valuation of Land Amendment Bill 2018. All in favor say aye. Aye. Any against? No. The ayes have it. Minister of Finance.
Madam Speaker, I beg to move in accordance with Standing Order 681 that the Property Tax Amendment Bill 2018 be committed to the Committee of the Whole.
Minister of Finance.
I'm terribly sorry, Madam Speaker. I don't think I was paying attention. I beg to move that a bill entitled An Act to Amend the Valuation of Land Act, Chapter 5803, be forthwith read a third time and passed.
Honorable members, the question is that a bill entitled An Act to Amend the Valuation of Land Act, Chapter 5803, be now read a third time and passed. All in favor say aye. Aye. Any against? No.
Mr. Imbert,
Yes, of course.
Dr. Rowley,
Yes.
Mr. Alwari,
Yes.
Mr. Young,
Yes.
Mr. Dialsing,
Yes.
Mrs. Robinson Regis,
Aye.
Mr. Hines,
Aye.
Mr. Mitchell,
Aye.
Mr. Garcia,
Yes.
Mrs. Critchlow Coburn,
Yes.
Mr. Ford,
Aye.
Mr. Dillon,
Aye.
Mrs. Webster Roy,
Aye.
Dr. Gadsby Dolly,
Aye.
Dr. Francis,
Yes.
Mrs. Jennings Smith,
Aye.
Miss Oliver,
Yes.
Mr. Antwine,
Yes.
Mr. Leons,
Yes.
Mr. Lee,
No.
Mr. Charles,
Nope. Spindly.
Dr. Rambachan,
No.
You know you want to say it.
Mr. Karim,
No.
Dr. Tiwari,
No.
Dr. Munilal,
No. I want.
Mrs. Gaidin Gopi Singh,
No.
Mr. Indar Singh,
No.
Dr. Khan,
No.
Mr. Padarath,
No way.
Mr. Parry,
No.
Ms. Ramdial,
No.
Madam Speaker, the results of the division is as follows. 19 members voting for, 12 members against, and 0 abstentions.
Honorable members, the result of the division, 19 members voted for, 12 members voted against, no members declined to vote. The ayes have it.
A bill entitled An Act to Amend the Valuation of Land Act, Chapter 5803.
Minister of Finance.
Thank you, Madam Speaker. Madam Speaker, I beg to move, in accordance with Standing Order 681, that the Property Tax Amendment Bill 2018 be committed to the Committee of the Whole.
Honorable members, the question is that the Property Tax Amendment Bill be committed to the Committee of the Whole. All in favor say aye. Aye. Any against? The ayes have it. The House will now go into the Committee of the Whole to consider the bill clause by clause.
A bill entitled An Act to Amend the Property Tax Act, Chapter 7604.
Members of the committee, is it agreed that we do clauses 1 to 9 in a block? And thereafter, we do clauses 11 to 22 as a block? Yes. So 1 to 9.
Clauses 1 to 9.
The question is that clauses 1 to 9 stand part of the bill. The question is that clauses 1 to 9 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 1 to 9 now stand part of the bill.
Clause 10.
The question is that clause 10 stand part of the bill.
Madam Chair, we are proposing at clause 10F, as it appears on page 6 of the bill, that the words appearing in the last 3 lines be attended to as follows. We strike the words where he is satisfied that he has a reasonable excuse for not making the application within the time frame. So the clause reads in totality as corrected in subsection 7 by deleting the words who fails to file an objection within the time frame specified in subsection 6 may, and then substituting the words and fails to file an objection within the time frame specified in subsection 1. The clause as it would read fixed in the law, if accepted, would therefore be the owner of land who is dissatisfied with the assessment of the board and fails to file an objection within the time frame specified in subsection 1 may apply to the board for an extension of time in which to file an objection, and the board on receipt thereof may grant the extension. So, Madam Chair, the words to be inserted, therefore, we would be striking at the end of the insertion words the following words, where he is satisfied that he has reasonable excuse for not making the application within the time frame. And the words to be inserted would only read, and fails to file an objection within the time frame specified in subsection 1 may. Comma. No comma. Yeah, may. Thank you, Madam Chair.
Okay, so
Madam Chair, if I were to put it succinctly for you, in clause F, we would be deleting the words appearing beginning in the 3rd line from the bottom, where he is satisfied that he has reasonable excuse for not making the application within the time frame.
okay. So do I have it correct? You'll be striking from comma.
Yes, ma'am.
Right. Okay. The question is that clause 10 be amended as follows. This would be at F by deleting in the 3rd to last line from the comma following me to time frame, comma, close inverted commas. Yes? Or does the inverted comma remain?
The inverted comma would remain.
All right. So the deletion will be from comma may to frame comma.
Exactly.
Okay. Yes. All right. So the question is that clause 10, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 10 as amended now stands part of the bill.
Clauses 11 to 22.
The question is that clauses 11 to 22 stand part of the bill. The question is that clauses 11 to 22 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 11 to 22 now stand part of the bill.
Clause 23.
The question is that clause 23 stand part of the bill. Minister of Finance.
It's just, Madam Speaker, we would like to change 2018 to 2016. 2017. Sorry, 17, my apologies, 2017. Collected for the year 2016 will become due and payable for 17 onwards.
The question is that clause 23 be amended as follows. In the last sentence, 2018 be substituted by 2016. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The question is that clause 23 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clauses 24 and 25.
The question is that clauses 24 and 25 stand part of the bill. Member Fumiari.
Madam Chairman, if I could just ask the Minister of Finance if there was a reason why the Agricultural Development Bank may have been left out from this schedule.
The inquiry is if there's a reason that the Agricultural Development Bank was left out of the schedule under clause 25.
We'll look into that for you, and if it is an oversight, we'll make the appropriate amendment in the Senate.
And secondly, Madam Chair, if I'm not sure if this question will be permitted, but I'll try it anyway. Would the Minister consider looking at zero rating the property tax for agricultural lands that are in productive use as an encouragement for farmers to continue in the rate that they're going?
That is something that we can certainly think about, but it is not something that we'd be willing to do at this point in time. But we'll certainly think about it.
While the thought is useful, and what it does if you do that, it creates a requirement to go and determine the veracity of the claim. Because if it's not in use, the tax is due. If it is in use, tax is not due. So then it puts the onus on the public servants to go and find out if it is or it is not. And it's not really worth.
And there's another point, as I made in my winding up. The tax on agricultural land is very small. So it's not, you're talking about dollars, a couple of dollars, $5, $10, whether it's waived or not for the year, whether it's waived or not. I don't think you should complicate it with a determination as to whether it's in productive use or not for something a couple dollars. I don't think it's better to have a clean thing, but we've put the tax so low on agricultural property that it's not going to be a burden on farmers.
The question is that clauses 24 and 25 now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clauses 24 and 25 now stand part of the bill. Honourable members, the question is that the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it.
Madam Speaker, I wish to report that the Property Tax Amendment Bill 2018 was considered in Committee of the Whole and approved with amendments. I now beg to move that the House agree with the committee's report.
Honourable members, the question is that this House agree with the committee's report on the Property Tax Amendment Bill 2018. All in favour say aye. Aye. Any against? No. The ayes have it. Minister of Finance.
Madam Speaker, I beg to move that a bill entitled An Act to Amend the Property Tax Act, Chapter 7604, be forthwith read a third time and passed.
Honourable members, the question is that a bill entitled An Act to Amend the Property Tax Act, Chapter 7604, be now read a third time and passed. All in favour say aye. Aye. Any against? No. I think the ayes have it.
A bill entitled An Act to Amend the Property Tax Act, Chapter 7604.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I beg to move that this House to now adjourn.
Honourable members, the question is that this House do now adjourn. All in favour say aye. Aye. Any against? The ayes have it. In accordance with Standing Orders 11. Is there a call for division? Maritime someone has asked for a division. In accordance with Standing Orders 11 and 12.1, this House now stands adjourned to Friday, the 9th of March, 2018 at 1:30 p.m.